customs, and then friends Mr. Knox, Mr. Casey and Ms. Pugh appear for the respondent, Mr. Holland. My Lords, there are a number of issues before your Lordships. The main one, I suspect, being the de facto corporate director issue, and I propose to start with that one. I'm in your Lordship's hands as to whether I should go first in relation to the other matters. Predominantly they are really grounds of appeal by my learned friend, but maybe we can sort that out when I get to it.
Well, as at present advised, we thought it was probably better that you should deal with all the matters. I think it's tidier that you do that and sit down, but we'll reflect on that and see how we get on.
Well, my Lords, dealing with de facto corporate director, your Lordships will have seen all the arguments in our printed cases and the numerous authorities cited. The reason, to a certain extent, why so many authorities have been cited is because there really is no authority specifically in point, save perhaps Mr. Justice Evans-Loam's decision in Secretary of State and Hall. No authorities that deal with the exact situation that we have here, namely the effect of a corporate director on the concept of de facto directorship. We're both trying to find the ultimate principles to fall back upon which this can be decided. So, my Lords, I don't propose to take your Lordships to many of the authorities we've cited in the case, because the relevant quotes are set out in them, and to a certain extent, a lot of the points raised are not in dispute. What I will deal with are the points raised in my learned friend's case and expose their reasoning as flawed and the difficult and strange consequences that would flow if they are correct. And we submit, of course, that there are potentially serious public protection issues arising as a result.
Is there any problem about the underlying facts? We've got a full agreed statement of facts and issues, and my impression is that the basic structure of the relationship between the companies and what Mr. Holland was doing, it was more or less agreed, and there's a lot of documents to support that. So it's the interpretation of the facts that is the real point.
I don't think there's any real dispute between us on the facts. There certainly is no dispute between us that from the 18th of August 2004, unlawful ultra-virus dividends were being paid by these companies, composite companies.
I have two very small points on the facts, neither of which matters, but I'd just like to try and get it straight. The agreed statement of facts says that each of the composite companies had 1A voting share, and then classes B, C, D, of which each contractor held only one share. But another document, in fact, your points of claim say that the contractors held up to 20 shares. And if you think about the £300,000 limit, if there were 50 shares out, each contractor would only be earning £6,000 a year, which sounds fairly improbable. Can you clear that up?
I could probably...
Well, if you can't now, perhaps you could at some stage. It's just whether the agreed statement of fact is right in saying that the contractor only held one share.
I think that is right.
And the other point, which again nothing is going to turn on, but in the defence to the points of claim, it was said it's not true that everyone got the national minimum wage and then the rest as dividend. It said because of IR 35, some of them got it all as salary. Again, it doesn't matter, but I'd just like to know what the right answer is.
It's fair to say, I think, that not all the employees, shareholders, got just the national minimum wage. There were there were different arrangements in relation to different employees.
Yes, the judgment does, to be fair, say in the typical case, but
yes.
It seems there were some cases where most of the money came out as wages and not as dividend.
There were some cases, I think that's fair to say, yes.
Could I ask a supplementary question on the facts? And again, it may not matter too much. There are references in the letters to the director's company being dormant. And I wasn't quite sure what the effect of that was. Did the company file accounts or returns? Was there evidence about this? Were there board meetings?
Your Lordship is right. It was described as a dormant company. I imagine it did file accounts, but it didn't have any. It didn't have any assets, and but as far as I understand, it would have had to have filed some form of account and returned to the Company's House.
Yes. Anyway, that matter doesn't seem to have been probed very much any further than that. I think it's recorded in your original claim that they were dormant, and the judge records it in his
Yes.
I think paragraph 36 of his judgment, without comment.
Well, it certainly is part of our case that Paycheck Directors, the corporate director, is a worthless and meaningless company. It performs no useful function. It provides no protection to anybody, whether shareholders or creditors, in the composite companies. Its only function, so it seems, and this is, I think, accepted by the other side, is to attempt to limit Mr. Holland's liability.
But it is a director.
It is the de jure director of the composite companies.
So your case, in effect, is that there were two directors. One the company and two
Yes.
the individual.
Yes, exactly so, my lord. For this purpose, one can ignore the capacity that Mr. Holland was acting in. Although capacity would be relevant as to whether Paycheck Directors itself was liable. If Mr. Holland is acting with authority of Paycheck Directors, Paycheck Directors will be liable for its corporate acts. However, it has no relevance to whether Mr. Holland himself is a de facto director.
Are they jointly and severally liable?
They would be, yes. They would be subject, if we are right that Mr. Holland is a de facto director, they would be subject to the same duties. My lords, it is accepted that if Paycheck Directors did not exist, that what Mr. Holland did in relation to the composite companies would be sufficient to constitute him as a de facto director. So the interposition of Paycheck Directors is the crucial fact. And his actions in themselves are sufficient to constitute him as a de facto director.
If it didn't exist, he'd be a de facto director of what?
Of all the composite companies, because of what he did in them. And this appeal will have to decide whether that interposition of Paycheck Directors changed anything in law. Of course, all his actions, the facts are the same. What he was doing, what he was deciding are all the same. But does putting Paycheck Directors between him and the composite companies get him off the hook?
Would your argument extend to every corporate director? Because surely in every case it could be said, well, the corporate director is interposed between the people who actually make the directorial decisions. And so every case you can look to the directors of the corporate director.
We say it wouldn't happen in every case. It depends on the facts. It depends on what the director of the corporate director is actually doing. If it's the case, and there's one of the authority I just referred to, Mr. Justice Evans-Loam's case in Hall, in that case the corporate director wasn't doing anything in the subject company, in the company of which it was de jure director. And
but somebody has to be doing it, because a corporate director needs a human being or human beings to make decisions.
Well, there were other de jure directors of the subject company in that case, and they were doing everything.
Oh, I follow, yes.
So there were three de jure directors of the company, two individuals who were doing everything, and the third was a corporate director. The issue was, is the director of that corporate director a de facto director?
Yes.
And Mr. Justice Evans-Loam says no, because it wasn't doing anything, and therefore its director wasn't doing anything.
But if there's a sole corporate director,
Yes.
what happens then? In what circumstances will a director of a sole corporate director not be a de facto director?
Well, what we would say to that is that it doesn't necessarily follow merely from the fact that the director is a director of the corporate director, that he becomes a de facto director. It depends on what he does. So one doesn't simply assume that the director of the corporate director is a de facto director. And we have in this case the example of Mrs. Holland. She was a director of Paycheck Directors.
Yes, but at the end of the day, there will still be someone who directs
Yes.
the corporate director.
Yes, well, we say that at the end of the day there has to be a human being.
Yes, and will that person necessarily be a de facto director?
If what he is doing is enough on the authorities to become a de facto director.
No, but assume that the corporate director does something which only a director can do.
Yes.
Will it necessarily follow that the managing director or the effective director of the corporate director in those circumstances be a de facto director?
We would say yes.
Well, that's very wide. That's a very
But would you qualify that by saying only if he himself is the sole effective director of the corporate director?
Yes. If he is the person that is.
I mean, if he was only one of a board of 8 or
Yes.
9 persons who were on the board of the corporate director, it would be different, wouldn't it?
You would have to look at what each individual member of that board was doing in relation to the subject company.
So that if, say, 6 out of the 9 directors taking an active part in decisions which were decisions affecting the company of which the corporation was a director, that those 6 would, as I understand it on your argument, be likely to be de facto directors.
I'm not sure.
I'm sorry, I didn't put that very clearly.
No, well,
But your argument would not confine itself to a corporate director which itself only has one director. It would necessarily extend to where the corporate director had a number of directors who were actively involved in making decisions that were passed through the corporate director affecting the company concerned.
It depends on the extent of their active involvement. Merely participating in board meetings, we would submit, would not be enough. But actually dealing with and activating the trading or business of the subject companies would be enough.
But if you got a board meeting where they were discussing the activity of the subject company, and they put it to a vote, and all 9 directors said, yes, that is the way the subject company should go, that's what it should do, then, as I understand it on your arguments, all 9, or whatever number you like to take, would be de facto directors.
Well, it would depend on how those decisions were implemented.
Does it depend to some extent on what the company itself is doing? I mean, one could have a situation where the company was a mere shadow. It's a name which exists, it's kept alive, but doesn't do anything significant at all. And that's simply the way it's run. One could have another situation where the company is actually quite active. It has board meetings, and decisions are taken and recorded in the normal way for board meetings to record their decisions. So the company is being used for what it really is, as a company. Is it that kind of factual inquiry?
If there is no other director, de jure director of the trading company, the subject company, there must be individuals that are not merely voting or attending board meetings of the corporate director, but are actually affecting those corporate decisions. It is actually that a person is actually causing the subject companies to act. And it is those individuals, whether or not it is on the back of a board resolution of the corporate director, or whether or not they actively voted on the board resolutions of the corporate director. It is what they go on to do and actually cause the subject companies to do in terms of their trading.
Would you say
or
the
whatever.
would you say the test is for the purpose of deciding whether people are de facto directors, remove the corporate director, take him out of the picture, look at what they're doing and say, on the assumption the corporate director was not there, is the conduct and action of the people, does that fit the de facto director requirements for the subject company?
Absolutely right, Mark,
That's
yeah.
the way you would put it.
Yes.
Yes, thank you
Absolutely
very much.
right. When considering de facto directorship, we say capacity is not relevant. It is not relevant to look at the person on behalf of whom the alleged de facto director says or appears to be acting. Capacity is completely irrelevant in this context. And I'm sorry.
Please go on. I was just going to say something, but I've interrupted you. If you'd like to finish what you were saying.
What I was going to go on to say was that the Court of Appeal's judgment in this case, in reliance on the Hydrodam decision, which your lordships will have seen, can't be limited to the situation of a corporate director. Necessarily, it goes way beyond that and would mean that if a person was acting in any capacity other than his own personal capacity in relation to a company, or can show that he was so acting, that would get him off the hook. He couldn't be a de facto director because he could come to court and say, but I had a lawful appointment as a consultant to the company. I was only ever doing anything pursuant to that consultancy agreement. So that capacity is relevant, and I can't be a de facto director.
Well, I was going to suggest that you might like to take us through such guidance as we can get from the authorities. You indicated at the beginning there's not a great deal, but perhaps it would help if you set out the way you see it, and we can work on from there.
Certainly, my lord. I've made the point that Paycheck Directors is a shell company, doesn't actually provide any useful function. I did want to show your lordships, just before turning to the authorities, what were the relevant acts in this case. The relevant acts in this case were the declarations of unlawful dividends.
I'm not quite sure where your proposition that the company in question was a shell company fits in. Does it? It's not an essential part of your argument, is it?
No, it's a forensic point, my lord. I accept
because
that.
you could have a perfectly viable company trading away in various spheres, but also acting as a director of the subject company. But on your analysis, whether or not it's a shell company is irrelevant.
It puts it in context, my lord, because it's there for a specific purpose, namely to limit Mr. Holland's liability. It has no other function, apparently. And the suggestion is that if Mr. Holland is not a de facto director, it's necessary for a liquidator or HMRC, as in this case, to proceed against it. Which
I follow that,
Yes.
and certainly it makes for I'm not trying to be rude in any sense, a good forensic point, but does it matter from the point of view of your basic argument?
No, it doesn't, my lord.
But it is
Our argument applies whether or not it is a worthless company.
But it's a fact that it's there, isn't it?
It is just a fact, and I think it brings into focus the point.
I follow that entirely, but it is, as I understand it, not essential to your argument.
I accept that, my lord.
And indeed, in one sense, not relevant.
I accept that.
I'm not trying to put words in your mouth, but
Yeah.
I'm trying to understand the basis on which you put your case, and that's I'm very
No, the issue for your lordships is whether a corporate director of any sort is effective to limit a director's liability.
Yeah.
If your lordships have the part 2 of the appendix, which is the one lever arch file, and my lords, I just wanted to take your lordships to, in tab 5 of that bundle, page 77, the numbers in the middle at the bottom of the page.
A resolution. Is it?
That should be exactly a minute, a so-called minute of a director's meeting.
I'm into the wrong bundle. We're looking at
Tab 5.
It's part 2 of the appendix to the statement
That's
of
right,
facts
that's tab 5.
and issues.
That's
Appendix to Statement of Facts and Issues, Part 2, tab
Tab 5,
5.
page 77. It's the numbers in the middle at the bottom of the page.
Oh, at page 77, yes, I beg your pardon, yeah, thanks.
And these are the minutes that were churned out by the computer every week on behalf of all the composite companies. So your lordships will see at the top of the page, Paycheck Services 9 Limited. That's one of the composite companies. Minute of a directors' meeting held on the 12th of July 2002. Present, M. Holland, Paycheck Director Services Limited. L.M. Holland, that's Mrs. Holland, Paycheck Secretarial Services Limited. And the signature is that of Mr. Holland, although that signature is also computer generated, for and on behalf of Paycheck Director Services Limited.
Would it have mattered if there'd been a full discussion and the minutes had recorded the discussion and then it had been resolved that the dividend be paid?
No, it wouldn't have made any difference, my lord, but the point is that this document is the document that is said to limit Mr. Holland's liability, because it is stated that he is only acting with his paycheck director's hat on. He is not liable. It is paycheck directors that is actually declaring the dividends, and
he would otherwise be personally liable. Is that right?
well, if we're right on that he was a de facto director of the composite companies, because this is the relevant act, and it's clear that he, as a human being, is passing the resolution. The issue is whether, because he is passing it on behalf of paycheck directors, that means he should not be held responsible for that act. That is purely a corporate act, he says, and it's something for which he should not be held responsible. The other side seem to be under the impression that we are saying this is not a corporate act. We accept it is an act of paycheck directors. It was the de jure director of the composite companies. It had to direct the payment of dividends.
And the act is the payment of an unlawful dividend.
Yes.
Is it?
Yes.
And what is it then that you rely on, that we can see on the face of this document? Is it simply the fact that Mr. Holland alone signed the minute?
Well, we can see that it purports to be Mr. Holland who is doing it, as the human being that is affecting it. He is the human being that is deciding that this dividend should be paid. And when it came to it in 2004, he was the individual who was taking advice and deciding to carry on and pay unlawful dividends. They say this minute gets him off the hook because he was only doing it as a director of paycheck directors. We say you can ignore paycheck directors because Mr. Holland was the person who was actually doing it. The fact that it's a corporate act of Paycheck directors does not mean it cannot also be a personal act of Mr. Holland.
But would I be right in thinking that you have to go behind the document to make the point you're making, that you ignore the de jure director? Because on the face of it, this is an act of the de jure director, isn't it?
Well, you ignore the de jure director for the purposes of considering whether Mr. Holland is a de facto director. We're not ignoring the fact that this is also an act of Paycheck directors. It is. But it is also an act, a relevant act, we would say, for the purposes of de facto directorship of Mr. Holland. And Your Lordship, I've already made the point, but it's worth bearing in mind again that Mrs. Holland, who is stated to be at this meeting, but on behalf of Paycheck Secretarial Services, she was also a de jure director of Paycheck directors. We have no evidence of any meetings of Paycheck directors actually taking place. We don't know whether that was so. But her involvement, as found by the trial judge, was insufficient. Her personal involvement was insufficient to constitute her as a de facto director. And that was because it was clear that Mr. Holland himself was the person who was making all the relevant decisions and the person who was in real control of the composite companies.
If it were a tort to pay the unlawful dividend, which it's not, is that right?
It's not a tort.
It's not a tort, and nor is it a crime.
Well, actually, Your Lordship maybe raises an interesting point as to whether maybe it would be a tort, but I'm not sure.
But if it were a tort,
yes,
then how is it put on the other side?
Well, Your Lordship raises a very important point, and I'll be coming on to that torts, for most torts, there is no capacity defence. You can't say, I'm committing this tort on behalf of another. You are liable for fraud, for instance. I'm going to come on to take Your Lordships to the...
So if I were the master of a ship and I negligently navigated my ship on behalf of the ship owner, I would still be liable,
Yes, more.
for example.
Yes, exactly so. And in fact, we say this provides the key to this question. The key to this question, we say, is the difference between voluntarily assumed duties and duties imposed by law. And most tortious duties are imposed by law. You can't contract out of them. And criminal liabilities are effectively duties imposed by law, whereas contractual liabilities, which are voluntarily assumed, and in that situation, it is open to the party to a contract to expressly exclude liability. And we would say that in that sphere, the sphere of voluntarily assumed duties, capacity could be relevant. But in the sphere of tort and crime, and we would say directors' duties, which are duties imposed by law, they cannot be excluded expressly, and therefore capacity will be irrelevant in relation to such duties. Now, I hope to make good that point by reference, as I said,
Well,
to
you
the...
can contract out of tortious liabilities, can't you?
Well, your Lordship may be thinking of a Headley Burn type of liability, which I accept is perhaps more analogous to a contractual type of liability, requiring a voluntary assumption of responsibility. But apart from that, I'm not sure that there is any ability to contract out of. One can't contract out of a tortious duty not to personally injure someone, for instance.
Well, where there are concurrent duties in tort and contract,
Yes.
you can certainly contract out
That-
of
that-
both duties.
Yes, because there is a pre-existing relationship between the parties, and the tortfeasor is able in advance to expressly exclude liability. So I accept it can't apply across the board in relation to tortious duties, but we would say that directors' duties are imposed by law, and directors cannot limit their liability. In fact, I wanted to show your lordships section in the Companies Act, which maybe your lordships are familiar with. It's in volume 8 of the authorities bundle. Tab 77. And if your lordships go to page 3 of that tab, you see section 232 of the Companies Act 2006. And this was a provision that appeared in the 1985 Act as well, slightly different terms. We have that here, section 310 of the Companies Act 1985. But this provides that any provisions protecting directors from liability for negligence, default, breach of duty or breach of trust is void. And similarly, any attempt by the company to indemnify directors. So, my lords, these duties are imposed upon someone who is a director. Fiduciary duties, the duty of skill and care, and they cannot be excluded. There's no concept in English law of limited liability of directors. The respondent relies, in a number of respects in their case, on limited liability, this leading to the concepts of separate legal personality, piercing the corporate veil, all Salomon principles. But that limited liability is nothing to do with the case that we have here. That is the limited liability of shareholders. That is the only concept in English law of limited liability in relation to companies. And it leads to those concepts of separate legal personality and piercing the corporate veil. But it is, despite that fundamental point, it is the respondent's argument that a director can perfectly legitimately limit his liability by the lawful use of a corporate director. That was why it was specifically done in this case. And we would submit that if it was so easy to limit liability in that way, it is extraordinary that nowhere in any textbook or any authority is that mentioned or even hinted at. And certainly, Mr. Justice Millett in the Hydrodam case, as he then was, didn't mention that there was any such concept. And why is that? Because it can't be right. Directors simply can't limit their liability. The whole point of de facto and shadow directorship is to not allow individuals to avoid or limit their liability. And it makes no sense for somebody who has complete control over everything that the company does to allow them to set up a structure, and one could conceive of an even more complicated structure that we have that we have in this case, a whole string of companies between the individual and the subject company, specifically designed to limit.
I follow that, but there has, of course, been this discussion as to whether or not corporate directors should be forbidden completely. And in some countries, they are forbidden completely. And the point perhaps could be made that the reason for forbidding them, or the reason for reaching the compromise in the section we've just looked at, is because, by interposing a corporate director, individuals are, other things being equal, relieved from liability. But if you're right in the way you're putting it, no one need worry about corporate directors because you can always go to the people who are running the corporate director.
Well, you can. You can always go. The reason why there's consideration for banning corporate directors is not because they can be used to limit liability. It's because they make the position not transparent. They make it more difficult to discover who is actually running companies. They obscure the position. That was the concern of the Company Law Review, and in fact they originally proposed banning it. And as your Lordship rightly points out, most other countries have indeed banned them. But there's no suggestion in the Company Law Review or in any of the discussion about the change in the law to what we have now, where there has to be a natural person on the board. This is because the use of a corporate director, it is perfectly legitimate to use a corporate director to specifically limit your liability. No suggestion of that whatsoever. And in our submission, it is an extraordinary proposition because if on the back of the Court of Appeal's judgments in this case, you are allowed to do that, it would be impossible to establish that such a structure was a sham. If you're allowed to set up a corporate director specifically so as to limit your liability, that must be legitimate. And how could you say that that is a sham structure? So it would be very easy to avoid the perils of disqualification, potential wrongful trading, and really a charter for the unscrupulous.
So are you going so far as to say that you can never, by a structure of this kind, limit your liability?
The structure itself cannot limit somebody who would otherwise be liable as a director.
It's not really a case of limiting liability at all, is it? It's a question of who is liable.
Well, it is effectively limiting liability for someone in the position of Mr. Holland to a case of dishonesty. One would have to show dishonesty, that fraud would unravel all in some respect. He would not be subject to the normal duties of a director, where mere honesty is not enough. The duties are much stricter than that. So it does effectively limit his liability. But why should it?
There's nothing in the Court of Appeal decision that in any way would affect the position if the scheme was set up for fraudulent or dishonest motives. Is there?
No, if there was a fraudulent motive, of course.
Because then you.
No, but I'm sorry. This, of course. I mean, I think we have got to concentrate on what sort of liability you're trying to establish. There's that case before Mr. Justice Lindsay. It's quite complicated. I don't know whether we're going to be shown it or not. He puts down 5 different ways of trying to get through to those directors, and the simplest one is, of course, if they are dishonest. If the board of the corporate director is engaged in a dishonest enterprise, then it's a straight dishonest assistance in a breach of fiduciary duty, and they're all liable, however many there are. But there's no suggestion that this is a case of dishonesty. And dishonesty is what Lord Nichols says in Royal Brunei and Tan is necessary now for dishonest assistance. So you have to look at other less high profile, but just to discuss liability without saying liability for what, does make it too imprecise, I think.
Well, we say that the liabilities are the ordinary liabilities, well-established liabilities of a director of a company. a director...
What would be
is
the
subject-
liability here? Suppose there was no corporate director, and Mr. Holland were a director of Paycheck Services 9 Limited, for example. Take the example of page 77. And a resolution had been passed to pay, signed by Mr. Holland, or he had decided as a director of Paycheck Services Limited to pay an unlawful dividend. What would be the nature of his liability?
His liability, well, we have an issue as to whether it's strict or fault liability, but it would be, we would say he'd be strictly liable for having made a misapplied company funds in the payment of a ultra vires and unlawful dividend.
And that's your primary case, and the alternative case is what? That he was negligent?
That he was
acted
negligent,
unreasonably.
yes.
And that, how do you put that? And what's the nature of that liability?
Well, that he we would say it would follow as a matter of course. In fact, the way the dividends came to be unlawful is because, as the trial judge found, that it was unreasonable not to make provision in the company's accounts for the liability to HMRC. So the crucial factor in determining whether the dividends were unlawful was actually unreasonableness. And so it would follow as a matter of course that it was unreasonable on the back of those accounts or notional accounts to pay the unlawful dividend.
And that would make the individual liable, the individual
Yes,
director
to the
liable.
company.
To the company.
To the company.
And is that an issue?
I don't believe it's an issue that if the corporate director was not there, that Mr. Holland would be liable. We have an issue as to whether he succeeds on his Section 727 defence because he behaved honestly and reasonably. And there's also an issue as to whether the liability is strict or fault liability. But subject to that, I think there's no issue that a director will be liable for causing his company to pay unlawful dividends.
And in Section 232, does a director include a de facto director?
That's an interesting question because, of course, someone is only made a de facto director in order to make him subject to the ordinary duties of a director. So if you had a provision that was purporting to exempt someone who might be a director, a de facto director, then yes, we would say that that too would be void, because director in that context must include in those very unusual circumstances someone who would be a de facto director.
It would be very odd if it wasn't so, wouldn't it?
Yes.
Because you could then get all sorts of exemptions from the company by the simple expedient of not getting yourself properly appointed as a director.
Yes, it would be a rather easy way around.
Can't be right.
Yes, I'm grateful. Yes.
Well, where do we go from here then?
Maybe I take your lordships to the Pakistan National Shipping case, because it's not a case of de facto directorship, but it does contain a lot of very useful points. It's in volume 7 of the at tab 60. And this was a decision of the House of Lords. And it concerned fraudulent misrepresentations by a director of the company, a Mr. Mehra, on behalf of his company called Oak Prime. And he said, and the Court of Appeal accepted, that his fraudulent misrepresentations were only made on behalf of his company, Oak Prime, and therefore he should not be liable. And the House of Lords disagreed. And if I could take your lordships, first of all, to Lord Hoffman's judgment at paragraph 20. And he says at paragraph 20, I come to the next question of whether Mr. Mayor was liable for his deceit. But the question in this way may seem tendentious, but I do not think it's unfair. Mr. Mayor says, and the Court of Appeal accepted, he committed no deceit because he made the representation on behalf of Oak Prime. It was relied upon as a representation by Oak Prime. That is true, but seems to me irrelevant. Mr. Mehra made a fraudulent misrepresentation intending SCB to rely upon it, and SCB did rely on it. The fact that by virtue of the law of agency, his representation and the knowledge with which he made it would also be attributed to Oak Prime would be of interest in an action against Oak Prime, but that cannot detract from the fact that they were his representation and his knowledge. And we would say the same applies in relation to Mr. Holland. He was the only human being involved in making the representation to SCB. And that is perhaps an interesting aside by Lord Hoffman, because we say he's saying there has to be ultimately a human being involved in making a fraudulent representation at the end of the day, and a human being therefore ultimately responsible for it. It is true SCB relied upon Mr. Mayor's representation being attributable to Oak Prime because it was the beneficiary under the credit, but they also relied upon it being Mr. Mayor's representation because otherwise there could have been no representation and no attribution. And then he goes on to discuss the Williams and Natural Life Health Foods case. That was an action for damages for negligent misrepresentation. My noble and learned friend Lord Stain pointed out that in such a case liability depended upon an assumption of responsibility by the defendant. As Lord Devlin said in Headley, Byrne and Heller, the basis of liability is analogous to contract. And this was the point that my Lord Clark was raising, that there's certain types of tort which are analogous to contract and involve some sort of voluntary assumption of responsibility. So there's clearly a distinction being made by Lord Hoffman between voluntary assumption of duties and responsibility and duties imposed by law. He goes on in paragraph 21, just as an agent can contract on behalf of another without incurring personal liability, so an agent can assume responsibility on behalf of another for the purposes of the Headley-Byrne rule without assuming personal responsibility. The Lordships decided on the facts of the case the agent had not assumed any personal responsibility. And he goes on to say, this reasoning cannot, in my opinion, apply to liability for fraud. No one can escape liability for fraud by saying, I wish to make it clear I'm committing this fraud on behalf of someone else. I'm not to be personally liable. Lord Justice Evans framed the question as being whether the director may be held liable for the company's tort. Mr. Mayor was not being sued for the company's tort, he was being sued for his own tort, and all the elements of that tort were proved against him. So again, the analogy with our case is close, because Mr. Holland, all the elements of de facto directorship are established as against Mr. Holland. And that is something that leads to duties being imposed upon him. Having put the question in the way he did, Lord Justice Evans answered it by saying the fact that Mr. Mayor was a director did not in itself make him liable. That, of course, is true. He's liable not because he was a director, but because he committed a fraud. And this goes back to the point of making towards the beginning, that the mere fact of being a director of the corporate director is not enough. Must be actually doing something. There must be positive action by the person before he can be considered to be a de facto director. Both Lord Justice Evans and Lord Justice Aldous treated the Williams case as being based upon the separate legal personality of a company. They referred to Salomon and Salomon. Lord Justice Aldous referred to Salomon and Salomon. My noble and only friend Lord Stain made clear the decision had nothing to do with company law. It was an application of the law of principal and agent to the requirement of assumption of responsibility. under the Headley-Burn principle. Lord Steyne said it would have made no difference if Mr. Williams's principal had been a natural person. So one may test the matter by asking whether Mr. Mayor had been acting as a manager for the owner of the business who lived in the south of France and had made a fraudulent representation within the scope of his employment. He could escape personal liability by saying it must have been perfectly clear he was not being fraudulent on his own behalf, but exclusively on behalf of his employer. And we say too that our case is really nothing to do with company law. It's not to do with piercing the corporate veil. It's not to do with the limited liability of shareholders, which is the principle in Salomon & Salomon. It is all to do with principal and agent. Whether Mr. Holland, as Paycheck Director's agent, can say he is not liable because my principal, Paycheck Directors, is the only person that's liable, or whether that is no defence, as was the case in this case. There's no defence to Mr. Mehra to say I was only doing this fraud on behalf of my company. So we see the distinction between voluntarily assumed duties and duties imposed by law. The point is picked up also in Lord Rogers' judgment from paragraph 35 onwards. And perhaps he also deals with this the red herring of shareholders' limited liability and its inapplicability in this situation. In paragraph 37, he says a hallmark of modern companies is that the liability of shareholders is limited. This is not a necessary characteristic of a commercial operation. Indeed, for some time after the Limited Liability Act, there were major trading entities which had been incorporated, but the investors in which were exposed to unlimited liability for the corporation's debts. This could and not infrequently did result in investors' ruin. By reducing and defining the potential risk to investors, limited liability opens the way for modern companies to raise the necessary capital for their business, either privately or on the stock market. For this reason, only in exceptional circumstances does the law allow a creditor of the company to pierce the veil of incorporation and fix the shareholders with personal liability. Although Lord Justice Aldous referred to lifting the corporate veil, the question of the limited liability of shareholders is irrelevant to the present issue, since Standard Chartered do not seek to make Mr. Mehra liable as a shareholder in Oak Prime. And just pausing there, that is also the reason why limited liability and piercing the corporate veil is not relevant to our case at all, because Mr. Holland isn't being sought to be made liable as a shareholder. Nor do Standard Chartered seek to make Mr. Mehra liable by virtue of his position as a director for the deceitful acts of Oak Prime or its employees or other agents. Rather, they seek to do no more than hold him liable for deceitful acts that he himself performed. No question arises as to whether he directed or procured the doing of tortious acts by others. And the C. Evans and Sons line of case is not in point. At the heart of the Court of Appeal's decision is the view that because Mr. Mehra is a director of Oak Prime, and acted as such when cheating Standard Chartered, his acts must be regarded solely as the acts of Oak Prime. He should have no personal civil liability for them. And then he goes on to deal with the submission that was accepted, that one can't escape the clutches of the criminal law by saying you're only committing the crime on behalf of your company. And then at paragraph 40, Lord Rogers...
And is this a case of the kind referred to by Lord Roger at page 973 at B, where he says directors may be personally liable if they direct or procure the commission of a wrongful act? I mean, is it your case that Mr. Holland here is directing or procuring a wrongful act, namely the payment of the dividends?
Well, we're saying he certainly caused the companies to pay unlawful dividends.
But do you need a label of de facto director to make him liable?
We do, because I think he's under. He would only be under a duty not to make unlawful dividends, to cause the companies to pay if he was such a director. think what that is directed at is more a secondary liability, accessory liability, and it may become relevant in the consideration of the Barnes and Addy line of cases, but. I suppose it would also be a question as to whether it was a wrongful act.
It seems to me it becomes circular then.
Well, I'm grateful to my lord. If there was another way to get to Mr. Holland, I would hope that we would have considered that, but I'm not sure. I'm not sure that does get to him. Can I just finish off with Lord Roger in letter C on page 974, where he makes the point: if he'd been a mere employee of Oak Prime and had done the same things and written the same letters on behalf of the company in that capacity, it could never have been suggested that Mr. Mehra was not personally liable for his fraudulent acts. His status as a director when he executed the fraud cannot invest him with immunity.
The emphasis really in that sentence is on the word director, isn't it? I mean, you take the previous sentence, the wider situation would apply. You can't escape from that by saying you're a director.
Exactly. The fact that you're a director rather than acting in any other capacity is irrelevant. The fact that it's a company that is the principal and the director is its agent is only relevant for the fact that a principal and agency relationship arise. One can actually test that by reference to our case. What if there was not a corporate director, paycheck directors, but a natural person that was the de jure director of the composite companies? Say Mrs. Holland was appointed as the director of the composite companies, but she delegated all her powers as a director as such to Mr. Holland, perfectly lawfully, and he carried on as he has done in the same way, controlling everything and running the companies. Surely the same conclusion would follow on the respondent's argument that he would not be liable as a de facto director. He's doing everything as the agent, the lawfully appointed agent of Mrs. Holland. And both Lord Roger referred to, and Lord Hoffman referred to the fact that Mr. Holland or Mr. Mehra would have been liable if he had been an employee of the company, just as much as if he was a director. So if Mr. Holland, instead of being appointed as a de jure director of Paycheck Directors, was merely an employee of it, does that work for de facto? Can he say, I was only ever acting as an employee of Paycheck Directors, therefore I shouldn't be held personally liable to the composite companies? We say no.
Well, I think you were saying a couple of minutes ago that the answer would be not that, but that an employee, a mere employee, would not have been under a duty. But it's interesting to see what Lord Rogers said in paragraph 41 at letter G, talking about whether there had to be a duty. Liability for deceit is so self-evident, we don't consider it as resulting from a breach of duty. Well, it may be that the payment of an unlawful dividend is so fundamentally contrary to company law that, again, to talk of it in terms of breaching a duty, it's more in the nature of a statutory prohibition, isn't it? But that's a point you made.
But whichever way, you can't escape liability. You can't in any way limit liability for fraud. Whether it's explained in terms of a duty, I think it can logically be explained that everyone is under a general duty not to commit fraud.
Yes, but Mr. Holland was not, it will be said against you that Mr. Holland was not dishonest, and it's been accepted throughout that he was not dishonest. So but the issue may be whether there is something in the act of paying an unlawful dividend which is fundamentally contrary to company law, even if not dishonest.
Well, we would say it is fundamental to company law. That's why there are such strict rules in relation to it, and the consequences that follow from it.
I mean, why can't you simply say, going back to the point at 973 at B, that what the case against Mr. Holland is that he directed or procured the commission of a wrongful act, namely the payment of a dividend contrary to a statutory prohibition, as my lord said.
That is limited to directors.
So
Directors
so
may
you
have
he has to be a. Well, why it is in that sentence, I agree, but why doesn't it apply to anybody? If you direct or procure the commission of a wrongful act, why are you not liable for that wrongful act?
Well, I'm sure what the other side say is that, well, he wasn't actually personally directing or procuring the commission of the wrongful act.
He was doing it on behalf of the company.
Correct.
But then you'd say the same as the
So we go
underlying
round-
principle of this case.
They may also say that in your points of claim, you tied your flag pretty firmly to the mast of de facto director.
Yeah, well, we can see that.
Yes, I think we'd have some difficulty in changing our case now in relation to that. What the case does show in our submission is that duties imposed by law, and whether fraud is to be considered a duty, it's certainly a liability that is imposed by law.
But how does this case help on the question whether Mr. Holland is a de facto director or not?
Well, why it helps is because it deals with the question of capacity. And the reason that the respondents say he is not a de facto director is because he was only acting in his capacity as a director of Paycheck Directors. And we submit that this case shows that where one is in the territory of duties imposed by law, capacity is no defence. It is no defence to say you were only doing these various acts on behalf of another. And perhaps
But you do accept that you still have to go further and show he's a de facto director.
Yes.
You can't do that simply by virtue of the act.
But we know that it's accepted that if Paycheck Directors did not exist, his acts were sufficient to constitute him as a de facto director. So are they able to say that because those acts were also being done on behalf of Paycheck Directors, he's not a de facto director?
I have a feeling we may be going around in circles.
Going back to Lord Clark's question, I mean, I really take from your answer to him that you would accept we don't actually get any direct assistance from this case as to what the test is, as to what a de facto director is. I mean, if that's
I don't think there's no dispute between us as to the general test for de facto directorship. We've set it out in our case, where what acts are sufficient to constitute someone as a de facto director, and that as is accepted, Mr. Holland's acts, looked at as his acts, would be sufficient to constitute him as a de facto director. He had complete control over the composite companies. It is only the placing of Paycheck Directors between him and the companies that enables him to say those acts were being done on behalf of Paycheck Directors, not in his own personal capacity. What this case shows is that in certain areas, and I accept this is dealing with fraud, in certain areas You can't say that. You can't say, I'm only committing this fraud on behalf of another. I'm only committing this crime on behalf of another. And it is of the essence of de facto and shadow directorship that the law is imposing duties on individuals because of what they are doing. Of course, no one wants to become a de facto or shadow director. The notion, which is emphasised in the respondent's case, that it is of the essence of de facto directorship that there is some sort of voluntary assumption of that role, we say is misconceived.
So really, the key sentence for you is the sentence on page 973 between G and H, in paragraph 39.
Yes. But, my Lord, it is also relevant, we would submit, in the way it deals with the fact that there's a company there. We're not in the territory of talking about shareholders' limited liability. We're not talking about piercing the corporate veil.
Yes.
And your Lordship will be aware that that is one of the ways, or a number of the ways, that the respondent puts their case, that is what we are effectively trying to do. We're trying to pierce the corporate veil. It has nothing to do with the fact that Paycheck Directors is a company. Capacity is irrelevant. And we say, in this de facto directors world where duties are being imposed on individuals who otherwise do not have any ability to contract out of those duties, that capacity should therefore be irrelevant.
So this resolution we've been looking at, is it accepted that that is an unlawful act by the company, Paycheck Directors?
When we're at the later stage, when they were unlawful dividends.
Yeah.
Yeah, the particular one we looked at was in 2002, but
Yes,
you
I'm
asked
sorry,
us
I
to
beg-
imagine that it was in September 2004.
I don't think there's any dispute that they were the same minutes being churned out 2 years
Assuming it was
later.
the 2004
Yes.
document we were looking at,
Yes.
is there any dispute that that is an unlawful act committed by Paycheck Directors?
I don't believe there would be, no.
And so you say, do you, that this is then an example of Mr. Holland saying, well, I was only committing this unlawful act on behalf of the company and I'm not liable. So that's the precise point rejected in
Yes.
the case we've just been looking at.
So he's really, you're saying, sheltering behind his position as the de jure director of the company.
He is, yes.
Paycheck Services.
Yes. Yes.
Or directors, I should say.
And but logically, we would say he would be saying the same result would follow if, even if he wasn't a de jure director of the company, but an employee to whom all the powers have been properly delegated, or indeed if Paycheck Directors was itself not a company, but a natural person. They have to go so far as to say that their argument on capacity works in that respect. That somebody avoids liability by setting up a particular structure that is effective in that respect. And the point is, the breadth of their proposition can be seen from paragraph 22 of their case. In paragraph 22 of their case, if your lordships have that, they refer to the case of Richborough, which we might need to come to, and in particular the quote at the bottom of the page, on page 13. They then go on to say, in other words, if without a lawful role or appointment, e.g. as shareholder or consultant under an agreed contract, but this is not as a director of the corporate director, but as a shareholder or consultant under agreed contract, a person interferes in the decisions taken by a company, then it may well be possible to say he's assumed the role of director and to fix on him the fiduciary and common law duties that go with this, particularly if there are in fact no other directors. But if his acts are fairly referable only to his lawful title as shareholder in or consultant to the company, then there's no basis for superimposing on him a further direct fiduciary and common law duty to the company. That is, in our submission, is indeed the extent of the Court of Appeal's judgments in this, and is extraordinary, because what it means is that if somebody has a contract with the company as a consultant to provide various services that cover everything that a director would otherwise be doing in the company, and that's a perfectly lawful contract, there's nothing wrong with it, and he then carries out that contract and is, just as Mr. Holland is, effectively running the companies, he will not be found to be a de facto director because he can point to his capacity as a lawfully appointed consultant to the company. So it doesn't depend on corporate directors or anything. It is the whole case comes down to whether capacity is relevant. And if capacity is relevant, then it extends this far. Somebody who is just a consultant to the companies, to the composite companies I'm talking about here, is just a consultant, and he can avoid de facto director, being found to be a de facto director. Now, I wanted to take your lordships to the only Court of Appeal authority on de facto directorship, which is KTEC, which is in volume 4. Which my Lord Walker will recall. It is in tab 35. And the case was very different, of course. The relevant individual concerned, Mr. Potier, was a deeply dishonest person, and there was really not much issue as to whether he ought to be found to be a de facto director. But he appealed the point, and my Lord Walker set out some of the earlier authorities and made some general comments. If your lordships would turn to the Court of Appeal judgment, which is towards the end, and to page 420. And just below letter C, there's the discussion in relation to de facto directorship. And my Lord quoted from the relevant sections the definition of de facto directors, and then referred to Canadian land reclaiming, which also appears in our case. Then your lordship referred to re-lowline, and then says at page 421, just above letter F, the mere assumption of office was also the way in which Mr. Justice Millett put the point in re-hydrodan. That was the case of wrongful trading under section 214, and Mr. Justice Millett distinguished sharply between a shadow director and a de facto director. And your lordships may well have seen that famous quote from re-hydrodan. I don't need to read that out. And Mr. Justice Millett, over the page, held that two directors of a PLC were not shadow directors of an indirect wholly owned subsidiary whose titular directors were two Channel Island companies. And then there's reference to that Richborough case and Cholly, a decision of Mr. Justice Jacob. And just below letter G in the quote from the Richborough case, the quote, the relevant quote is the last sentence. It also seems to me that if it is unclear whether the acts of the person in question are referable to an assumed directorship or to some other capacity, such as a shareholder or, as here, consultant, the person in question must be entitled to the benefit of the doubt. The judge, that's referring to Mr. Justice Reimer, the trial judge in this case, then referred to findings of fact which he'd already made, that is, that the company was intended to be beneficially owned directly or indirectly by Mr. Kayser and Mr. Potier in shares of 80% and 20% respectively, and Mr. Potier's services to the company were not rendered as an independent fee-earning consultant or advisor. The judge then went on to discount his interest as a shareholder, since the company's articles followed the almost universal practice of entrusting the management of its business to the board of directors. I have to say I find that particular sentence in the judge's judgment less than persuasive. The judge had just looked at the reality of the situation. Mr. Potier was devoting a great deal of time and effort to the company's affairs, not in the hope of earning professional fees as a surveyor, but in the hope of obtaining a valuable shareholding for a negligible, indeed nil, pecuniary outlay. I think that Mr. Justice Reimer is rather straining his reasoning at this point, probably out of deference to Mr. Lloyd QC's reference in Richborough to some other capacity such as shareholder. Now in our submission, the Lordship was not saying that capacity as such should be a complete defence to de facto directorship. The way that sentence in Richborough was interpreted by the trial judge in our case, we would submit is correct, that what was being referred to was whether the quality of the acts by the person are sufficient to constitute that person as a de facto director. And one can look at the particular role that he may have been performing in the company to test whether those acts were sufficient to become a de facto director. He was not, and in our submission, Court of Appeal was certainly not endorsing any general capacity defence to de facto directorship. And then Your Lordship dealt with the facts, the particular facts of the case, and found that the trial judge's conclusion that Mr. Potier was a de facto director was inevitable and incontrovertible. Then below, in letter F, there is the quote from the Trolley case, first instance decision of Mr. Justice Jacob, in which he says, it may be difficult to postulate any one decisive test. I think what is involved is very much a question of degree. Court takes into account all the relevant factors. Those factors include at least whether or not there was a holding out by the company of the individual as a director, whether the individual used the title, whether the individual had proper information, which to base decisions, whether the individual had to make major decisions, and so on. Taking all these factors into account, one asks, was this individual part of the corporate governing structure, answering it as a kind of jury question? In deciding this, one bears very much in mind why one is asking the question. That is why I think the passage I quoted from Mr. Justice Millett is important. There would be no justification for the law making a person liable to misfeasance or disqualification proceedings unless they were truly in a position to exercise the powers and discharge the functions of a director. Otherwise, they would be made liable for events over which they had no real control, either in fact or law. And we'd submit that that is absolutely right, and it encapsulates the rationale for de facto directorship, namely, it is to make liable those who are in a position truly to exercise the powers and functions of a director. Basically, those people who are in a position to make the company's decisions and to protect creditors and shareholders. And he was quite clear that that control, one has to look at the facts.
You read out my summary of the effect of Hydrodam without critical comment, but you could in fact have said that what Mr. Justice Millett actually decided was that it was so badly and embarrassingly pleaded that it should be struck out, that it was simply a strikeout, as you mentioned in your printed case.
Yes, but I have to accept that it has achieved some sort of prominence.
Well, it has, because Lord Millet's pronouncements, even as a first instance judge, are naturally accorded huge respect, although these particular comments don't seem to have received universal approbation in some of the later cases. Nobody's ever quite brought themselves to say they're wrong, I think. But
no, well, your Lordship went on to deal with that, in particular whether whether the two concepts of de facto and shadow directorship are indeed mutually exclusive. And I think it's now accepted that they're not mutually exclusive, and that there can be situations when a person could be both a shadow director, which of course has a statutory definition, and the de facto director. The other respect in which has been doubted, or which it can fairly be said that the concept has moved on in the last 20 years, is as to whether somebody has to be held out as a director in order to be a de facto director. Because going back to the quote on page 421, just below letter G, Mr. Justice Millett says, a de facto director is a person who assumes to act as a director. He is held out as a director by the company. And that is certainly not a necessary factor in determining whether someone is a de facto director on the authorities as they've developed since then. And we would, what Mr. Justice Millett did not do in Hydrodan, and we may need to look at it a bit more carefully, he certainly did not think there was any issue of piercing the corporate veil, which is the way that it is put by the respondents. And one would have thought that if Lord Millet had felt that that was the territory that we were in, there might have been some comment about piercing the corporate veil. Nor we submit, and do submit, was he advocating that there should be any general capacity defence in this area. But your Lordship continued at the bottom of page 423 at letter I, saying, I do not understand Mr. Justice Jacob in the first part of that passage to be enumerating tests which must all be satisfied if de facto directorship is to be established, simply drawing attention to some, but not all, of the relevant factors, recognising that the crucial issue is whether the individual in question has assumed the status and functions of a company director so as to make himself responsible under the Act, as if he were a de jure director. And in the respondent's case, they rather suggest that what your Lordship was saying was that there has to be some sort of willing, voluntary assumption of that status. As we would submit that there has to be simply a mere assumption of office. It's not, obviously as I've said before, any alleged de facto director will say, well, I wasn't intending to assume the status and functions of a company director, so I can't be one. That can't be right. What is the question? The question that has to be answered is whether the person is doing enough within the companies, within the subject companies, such that he has assumed that status. And then your Lordship made those comments on Mr. Justice Millett's observations in Hydrodam that de facto and shadow directorship do not overlap. The alternatives in most, perhaps all cases, are mutually exclusive. I readily agree that's so in most cases, and Mr. Justice Millett's observations have undoubtedly had a salutary effect, discouraging the Secretary of State and his advisers from routine reliance on the two concepts in the alternative, with insufficient analysis of the real grounds of complaint. However, the two concepts do have at least this much in common, that an individual who was not a de jure director is alleged to have exercised real influence, otherwise than as a professional advisor, in the corporate governance of a company. Sometimes that influence may be concealed, sometimes it may be open. Sometimes it may be something of a mixture, as the facts of the present case show. And then you refer to Mr. Potier, whom the judge found to be a dishonest and unscrupulous man, a liar, cheat, and a forger, good reason not to be appointed as or to be held out as a director of the company. In 1992, he'd already received, or must have known that, so it's quite clear that Mr. Potier obviously would not be a willing assumer of the status and functions of a company director. He was going to receive adverse publicity in connection with Scottish companies. The judge said, this is not a case in which Mr. Potier was lurking in the shadows. He was out in the sun, openly acting as director and was held out as such. The judge had a much longer, more direct exposure to the facts of the case than this court has had. Nevertheless, I have to say, I doubt whether the position was quite as clear-cut as that. Mr. Potier was deeply and openly involved in the company's affairs from the outset. He did his best to avoid being seen to act as a director, using his office as de jure secretary and his professional status as camouflage. The pressure events made it impossible for him to maintain the pretense on every occasion. Some very important occasions, he openly acted as a director. Now, my lord, that is really what Mr. Holland is doing, we would submit. He is using his position as director of paycheck directors as camouflage. Not saying that he's anywhere near the same category as Mr. Potier, but Mr. Holland is using it as cover for what was really happening. He was really running the show, and in our submission, there is certainly nothing in KTEC that suggests that capacity can be used as a way of avoiding becoming a de facto director. One clearly looks at the facts and sees whether that person is exercising real influence in the company, irrespective of the capacity in which such influence is being exercised.
Yes.
So, my lord, that is the last word, essentially, from the Court of Appeal on de facto directorship. I wanted to deal with the respondents' so-called 5 objections to the principle.
If you're going to come to the cases, the later cases, which I think you submitted, suggested that the holding out and actions such as that are now not regarded as necessarily conclusive or required.
I can do.
I wasn't suggesting you take out of your course in any way at all, but
yes.
Speaking for myself, it would be helpful to have your submissions on the cases which you say modify what would, on one reading, appear to be Lord Millet's requirement of holding out and professing to be and so on. Yes, Lord. The reason I was suggesting that is, of course, it's likely to be submitted by the respondents. That's the last thing Mr. Holland did. He never held himself out to be or professed to be a director of the subject companies. So at some stage, I'd like to hear your answer to that.
Yes. They've never used that, can I put it this way, they've never used that as a reason for suggesting that Mr. Holland would not be a de facto director of the company, because they've accepted that if paycheck directors did not exist, then what he was doing was sufficient on the relevant tests for de facto directorship, that he's not a... Yes, I follow that but that is working on the assumption that the director, the corporate director, doesn't exist. But it did exist, and could it not be said against you? Well, if you look at what Lord Millet said, where is the evidence that Mr. Holland held himself out to be, or professed to be,
a director of the subject companies?
There is no evidence.
No, from which it follows, as I understand it, you're saying that that isn't in fact a necessary requirement.
Yes. Well,
I'm not saying
it's
you're
not.
right or indeed wrong about that, but,
Yeah.
but it did strike me as a reasonably important point when you said, well, this sort of requirement appears to be modified in later cases.
Certainly, in later cases, there was the Cholly case, and it was dealt with to a certain extent in paragraphs 23 to 26 of our case, and quite a long quote from these are all first instance decisions and reflect the development of the law in disqualification cases, which is where most of the development has happened, and the emphasis now is on in those cases is whether the person is a part of the corporate governing structure.
Yes.
Whether that person has a...
Mr. Holland being a shadow director doesn't get you home, does it?
Under the section 212 of the Insolvency Act does not include shadow directors.
But it does include anyone involved in the management of a company. I mean, that's the bizarre point. That
Well, it's a very old section. Obviously, it predates shadow directorship. But your lordship is right.
I mean, if you imagine someone saying, now we've invented the concept of shadow directorship, why don't we pop it into section 212? I mean, the answer would be that it would be redundant there, wouldn't it? In view of section 212(1)(c).
Well, there may be an issue as to whether a shadow director who is issuing from afar directions and instructions to the board, whether that person is sufficiently concerned in the management.
I suppose there might be, yes.
And it is a mystery as to why shadow directorship has not been brought into section 212 in the way that it has been brought into section 214, wrongful trading, liability for wrongful trading. Of course, there's been plenty of opportunity for it to do so, but section 212 hasn't actually changed in any material
But you don't
respect.
find the existence of section 212(1)(c a convincing answer to that, do you?
Well,
Its language could hardly be wider, could it?
it is wide. The reason, I don't know whether your lordship is effectively asking me, why didn't we rely on
No,
that?
I wouldn't be so rude as to ask that.
Well, the reason is because merely being concerned in the management would not itself therefore lead to a duty.
Well, that comes back to what
Yes.
I was trying to say earlier, that you have to see what liability you're talking about,
Yes.
rather than simply looking at construing section 212 in isolation from the context of
Great.
what you're trying to bring home to someone.
Yes. So even if section 212(1)(c does actually incorporate somebody who might otherwise be a shadow director, it doesn't necessarily lead to that person being subject to that duty or potential liability. That's the difficulty. And of course, disqualification orders themselves are very wide, not just limited to disqualifying a person from being a director in a company, but also being concerned directly or indirectly in its management. I suppose there would be an issue as to whether such a person would be a shadow director or not. One would hope that it would cover somebody acting as a shadow director, but going back to my Lord Savile's point, no, we don't allege shadow directorship, but of course the way the arguments have developed and the way the Court of Appeal dealt with this issue was that they were one and the same. If capacity works in terms of providing a defence to de facto directorship, it also works on shadow directorship. And the Hydrodam decision, Miss Justice Millett's decision, was essentially a shadow directorship case. Even though de facto was pleaded as an alternative, the analysis was done on the back of shadow directorship. My Lord, I don't know whether it would be helpful just to take Your Lordship into our case, to paragraph 25 and the reference. There's quite a substantial quote set out from Miss Justice Etherton, as he then was, judgment in Secretary of State for Trade and Industry and Hollier. And the case is in volume 6 of the authorities at tab 52. But he analyses, maybe we should just look at that because we can see how he analyses.
So we're picking it up at paragraph 68, are we?
If I could just maybe... Yes, well, it actually starts at paragraph 61 on page 23.
Yes.
And the Lordships can see that there's a long discussion as to where the authorities are in relation to de facto directorship. And he quotes from paragraph 65, Hydrodam. And if Your Lordships look at the bottom of the page, paragraph 66, Mr. Justice Etherton says there are two difficulties with that description of a de facto director. First, it seems wrong in principle that it is a necessary characteristic of a de facto director that he or she is held out as a director by the company. Such holding out may be important evidence in support of the conclusion that a person has in fact acted as a director, but it appears to be far too narrow a test to embrace all those who have discharged functions normally and most appropriately carried out by a director. And then he refers to Mr. Justice Jacobs' decision in Cholly to the same effect. Secondly, Mr. Justice Millett's statement that the functions or actions of a de facto director must be those which can properly be discharged only by a director and must not merely be those which can properly be performed by a manager below board level, do not help identify what such functions or actions may be. He then has quite a long analysis of really all the authorities following Hydrodam. I don't think I need to take Your Lordships through.
So you take us to paragraph 81.
81, yes.
Yeah.
Yes, my Lord. That's the summary.
Yeah.
Where certainly Mr. Justice Etherton thinks we are in the development of the law. It says, on the basis of the analysis above, I summarise as follows the principles to be applied in determining the proceedings under the 1986 Act whether the defendant was a de facto director. 1. The touchstone is whether the defendant was part of the corporate governing structure. 2. Inherent in that touchstone is the distinction between someone who participates or has the right to participate in collective decision-making on corporate policy and strategy and its implementation on the one hand, and others who may advise or act on behalf of or otherwise for the benefit of the company, but do not participate in decision-making as part of the corporate governance of the company. Accordingly, the test is not satisfied by someone who was at all times and in all material decisions subordinate to the de jure directors. The defendant may have been a de facto director even though he or she did not have day-to-day control of the company's affairs, and even though he or she was only involved in part of the company's activities. The issue is to be determined objectively on the basis of all relevant facts. Whether the defendant was held out by the company or claimed or purported to be a director, and whether the defendant had access or the ability to obtain access to relevant company information is likely to be highly relevant and may be decisive. Factors such as a family relationship with other admitted directors and the defendant's financial interest in the company may also be relevant, sometimes supporting, sometimes negating the allegation that the defendant was a de facto director. De facto directorships and shadow directorships are alternatives, although there may be cases, particularly where the defendant's influence in the corporate governance was partly concealed and partly open, where it may not be entirely straightforward which of the two descriptions is most apposite. That final point, picking up the point from Re Catek. So, my lords, obviously, first instance judges are dealing with this issue quite a lot, and this is making clear that it is a factual inquiry as to whether what the person was doing was at a sufficiently high level within the companies such that he should be deemed to be a de facto director. If there are other de jure directors, he's got to be on effectively a level equal pegging to them. If there are no de jure directors, well then, obviously, if he is the person that is controlling all the company's affairs, then he will be a de facto director. Obviously, sometimes difficult to disentangle exactly how or who is making whatever decisions. But in our case, in our submission, there's no doubt it was all Mr. Holland. So on that test, clearly, Mr. Holland satisfies it. Question is whether Paycheck Directors changes it.
Although he doesn't satisfy the test of being held out by the company or claiming or purporting to be a director of the subject companies, does he?
But that's only a factor.
Well, I'm not saying it's more than a factor, although Justice Heatherton, as he then was, thought that those matters were likely to be highly relevant.
Yes. I can't deny that he thought that would be highly relevant, but they are by no means the only factors.
Indeed.
And it's clearly been held that it's not a necessary factor.
But what would you say if it was suggested that those particular factors are not present in this case, and therefore the conclusion is at best that he was a shadow director? I assume your answer to that is, well, how can he be? Because there's nobody else there to direct or to tell what to do.
Exactly. Well, except for the company.
Except
the corporate
the company,
director.
yes.
There has to be somebody who is receiving, or something that is receiving the directions and instructions.
And you say the corporate director isn't good enough. There has to be some other human being.
Well, if the corporate director is good enough, then it's effectively him giving. He is the only person who can receive those directions and instructions on behalf of Paycheck Directors. So he's doing one and the same. He's being a shadow director, and he's also being the recipient of those directions and instructions, and thereby causing it to act. Maybe that would be sufficient for shadow directorship. We haven't really explored that issue because obviously it doesn't get us home under section 212.
The origin of the rule that the directors are liable is that they're treated as trustees, and that's Flitcroft.
In relation to unlawful dividends.
In relation to unlawful dividends.
Yeah.
Could it be said that here the directors of the corporate directors assumed the duties of trustees by effectively managing the company?
And thereby assumed fiduciary duties towards the company beneficiary.
So that you don't need the label of directors. I think the reason I feel we're going round in circles is simply that once you attach the label, you have liability, And then the question is whether you have liability is whether you attach the label.
But even though they would be akin to, he would be possibly akin to a trustee, the money, the dividends that were paid, were never, he never had legal title.
No, it's not that type.
It's not actually a
It's not that
trustee.
type of trust.
No.
But looking, I think this may fit in with what's just being said. If you look at factor 4, after the bit about holding out, he refers to the question whether the defendant had access or the ability to obtain access to relevant company information. And that would be likely to be highly relevant. And if you put yourself in the position of somebody who might be thought to be under a fiduciary duty, that would be highly relevant.
Well, certainly somebody shouldn't be placed under a fiduciary duty unless they were able to obtain access. I accept that. But in our case, of course, there would be no... Mr. Holland obviously had access to all relevant company information. And there was that's dealing with a situation where... in fact, it's dealing with a situation where even though the person is perhaps doing acts that might otherwise only be done by a director, actually there was somebody far more powerful within the company who could prevent access to necessary information that would that a director needs in order to properly carry out his duties.
Well, is there anything more you'd like to take from this part of your case before we go to what you were going to go to, which I think were the 5 main objections, which we find in paragraph 11 of the respondent's case? At least we find the heading set out there. Don't let me take you out of order, please.
No, I was certainly going to deal with that, Lord. The first so-called objection says that what we are suggesting is inconsistent with the scheme of the 1985 Act. And we would submit that misses the point entirely, because this is all judge-made law. It's not inconsistent to allow there to be sole corporate directors, as the 1985 Act did, but also have a test for de facto directorship that ignores capacity and looks at actual action, the real facts, looks at the substance. There is no discernible policy in the 1985 Act or the 2006 Act that says that a director can legitimately set up a structure allowed under the Companies Act in order to limit his liability. On the contrary, and as I've shown your lordships, the policy seems to be the reverse, that directors can't actually limit their liability. So we would submit that, in fact, the respondent's case is contrary to is inconsistent with the scheme of the Act. The second objection is that HMRC misstates the rationale of de facto directorship. And they emphasise in paragraphs 13 and 14 of the case that the de facto directorship concept derives from usurpation and involves a voluntary assumption. One can see the final 5 lines of paragraph 13. By assuming voluntarily so to act, he assumes also the direct fiduciary and common law duties of a director. Where he acts honestly and within his authority as a director, the corporate director, there's no such usurpation or interference, nor is there any assumption of office He's doing only what he's authorised to do on behalf of the corporate director. Well, we would submit that way of characterising assumption of office is not correct. It is not of the essence of de facto directorship that there is a voluntary assumption of responsibility or office. This is something that is imposed on somebody who acts in a particular way. And in paragraph 14, they again suggest that there has to be some sort of intention on the part of the alleged de facto director. Because they say 8 lines down without intending to do so. They say at the final sentence that would be to impose a duty inconsistent with the very structure which the courts recognise to be lawful and effective and under which he has operated. We say, why does it matter whether he was acting within his lawful authority or not? That would only be relevant to whether Paycheck Directors itself is liable, namely whether it's a corporate act of Paycheck Directors. And it is only inconsistent with the lawful structure that he has set up if one assumes that such lawful structure is effective to limit liability. Perhaps goes back to my Lord Collins's point that we're going around in circles, but surely it can only be inconsistent in imposing a duty if you are entitled in the first place to limit liability. And what is the rationale of de facto directorship that the respondents argues for? It's not clear. They don't spell it out. And it is unclear why the rationale that we suggest applies, namely those who are responsible, those who are in a position, quoting from the Cholly case, to prevent damage to creditors, those persons who have real control, either in fact or in law, should be held responsible. Now, the Hydrodan case, which I think, even though, as my Lord Walker said, can be explained on a purely pleading point, and we seek to do so, I think it may be important just to take your lordships to it,
yes,
because it was the basis for the Court of Appeal's decision. It's in volume 4 of the authorities at tab 34. And your lordships will probably by now be familiar with the structure that existed in that case. It was not of course, we're not dealing with a normal corporate director. We're dealing with an alleged shadow director, the ultimate parent company of the subject company, Hydrodam, the ultimate parent being Eagle Trust. And there were a number of companies in between Eagle Trust and Hydrodam. Hydrodam itself had 2 corporate directors. And if your lordships go into the judgment, we can see that on page 181, at letter G, there's an explanation that Eagle Trust had 8 or 9 directors, some of whom were executive directors and some of whom were non-executive directors. As one would expect, the executive directors were also directors of MCP and of Landsaver 19, the operating companies, but they were not directors of the company. The titular and only directors of the company were 2 Channel Island companies, Tuscan Investments Limited and Ithaca Investments Limited, which were appointed directors of the company on the 18th of March, 1986. And so what happened in this case was that the liquidator pursued 14 different defendants. One can see this from letter B on page 181, accusing them of wrongful trading. And those defendants included Eagle Trust itself, one of its subsidiaries, and all its directors. Two of those directors, who were non-executive directors of Eagle Trust, applied to strike it out in the Northampton County Court and failed, but succeeded before Mr. Justice Millett. This appears to be perhaps an extempore judgment, or possibly a judgment delivered the next day. We've seen, I think, the quote, and perhaps I don't need to go through that, on page 182, about the distinction between different types of directors, de jure directors, de facto directors, and the important statement of Lord Millett at letter D, that liability for wrongful trading is imposed by the Act on those persons who are responsible for it, that is to say, who were in a position to prevent damage to creditors by taking proper steps to protect their interests. Liability cannot sensibly depend upon the validity of the defendant's employment. We say that that statement is an accurate statement of the modern rationale for de facto directorship, namely those who are in a position to prevent damage by to creditors are to be held responsible for it. And that is clearly, in our case, Mr. Holland. And then over the page, at the top of page 183, we have the discussion as to who is a de facto director, which we've dealt with, and the following discussion of shadow directorship. And then just below letter E, Lord Millett says, in the present case, there were titular directors of the company. They were Channel Island companies. That fact alone may be sufficient to justify an inference that they were accustomed to act in accordance with the directions of others, in which case they were shadow directors of the company. The fairly clear indication there from Lord Millett that one would expect when you have a corporate director, much like the one that we have in this case, that there is assumed to be somebody else behind it, somebody who is going to be ultimately liable for whatever it does. Certainly no suggestion that it can be used by way of a defence to an allegation of de facto directorship.
We're not told which of the Channel Islands it was, but if it was one of the smaller ones, like Alderney or Sark, it is notorious that probably minutes were faxed to them and they were faxed back again. I mean, which makes it quite a surprising case for Mr. Justice Millett to say there's a complete difference between shadow directors and de facto directors, because someone would have been sending the faxes, and it seems to me they probably would have fallen pretty well into both categories, but
yes.
There it is.
But it's certainly not suggesting that even if they do everything properly and they get a signature from whoever is in the Channel Islands on the relevant minutes, and it all appears to be being done in the name of and on behalf of the corporate director, that in some way relieves the people who are really deciding matters from from liability. And so the case was argued with a very broad plea, as one can see from letter H, that Dr. Hardwick, as a director of Eagle Trust, is, with the other directors thereof, collectively responsible for the conduct of that company in relation to the company. It's therefore the liquidator's case that Eagle Trust was a director of the company, presumably a shadow director, and Dr. Hardwick's liability is based exclusively upon the fact, being the only fact alleged against him, that he was one of the directors of Eagle Trust. As one of the directors of a shadow director, it is alleged he was one of those collectively responsible for Eagle Trust conduct, and was accordingly a shadow director of the company. My judgment, the conclusion does not follow from the premise. Liquidator submitted that where a body corporate is a director of a company, whether it be de jure, de facto, or shadow director, its own directors must ipso facto be shadow directors of the company. My judgment, that simply does not follow. And we would submit that that is the only ratio of this case. That it does not follow merely from the fact that somebody is a director of the corporate director, that that person is thereby a shadow director or indeed a de facto director, because it must apply to both. In my judgment, that simply doesn't follow. Attendance at board meetings and voting with others may in certain limited circumstances expose a director to personal liability to the company of which he is a director or its creditors, but it does not without more constitute him a director of any company of which his company is a director. And there's been huge debate as to what is meant by the more in that sentence. What more is required in order for that person to be constituted as a director? We say, in our case, Mr. Holland couldn't have done more. He did everything. It's not alleged against Dr. Hardwick that he did anything at all in relation to the affairs of the company, not even that he voted as a director of Eagle Trust in respect of any matter in relation to the affairs of the company. In my judgment, the mere fact that Dr. Hardwick was a director of Eagle Trust does not establish that he was either a shadow director or de facto director of the company. Expression collectively responsible obscures the relevant legal relationship. By reason of his appointment as the director of Eagle Trust, Dr. Hardwick owed fiduciary duties and a duty of care to Eagle Trust. It does not follow he ever gave instructions to the directors of the company. All the directors of the company were accustomed to act on his instructions. Nor does it follow that he ever acted as a director of the company. And of course, we have the analogous situation of Mrs. Holland. That merely the fact that she is a de jure director of Paycheck Directors does not make her collectively responsible or that she's done enough in order to constitute herself as a de facto director. There has to be something more. Then carries on, it's possible, although not so alleged, the directors of Eagle Trust as a collective body gave directions to the directors of the company, and that the directors of the company were accustomed to act in accordance with such directions. If they did give such directions as directors of Eagle Trust, acting as the board of Eagle Trust, they did so as agents for Eagle Trust, or more accurately, as the appropriate organ of Eagle Trust. And the result is to constitute Eagle Trust, but not themselves, shadow directors of the company. Now, in our submission, Lord Millett is not saying that capacity is relevant. What he is saying is that capacity is relevant for the purposes of determining whether Eagle Trust itself becomes a shadow director of the company. This is far removed from our situation. Eagle Trust had no lawful authority, had no definable role within its subsidiary, had no power to act within the subsidiary, so far as we're aware. But it is sought to make Eagle Trust itself liable as a shadow director for its subsidiaries' actions. And the only way that can be done is by showing that directions and instructions were actually given on behalf of Eagle Trust to the subsidiary board. And he then continues, in practice, in a case of the present kind, it is much more likely that it will be found that the executive directors of the ultimate parent company, or some of them, have from time to time individually and personally given directions to the directors of the subsidiary and thereby rendered themselves personally liable as shadow directors of the subsidiary. But if all they've done is to act in their capacity as directors of the ultimate holding company in passing resolutions at board meetings, then in my judgment the holding company is the shadow director of the subsidiary and they are not. Now, the way that has been interpreted by the respondents and by the Court of Appeal is saying that whenever something is done on behalf of a corporate director, and it doesn't have to be a de jure corporate director, and in fact, as we've seen, it can be on behalf of any person who can act in relation to the subject companies, then that is purely an action of that alleged corporate director and not of the individuals behind it. In our submission, this case is was decided by Mr. Justice Millett on the grounds of wholly inadequate pleading. Clearly, it's inadequate simply to allege that directors of Eagle Trust are collectively responsible, that each and every one of them, irrespective of what they are actually doing vis-à-vis the subsidiary company, each and every one of them is, merely by the fact that they are directors of Eagle Trust, that they are to be considered shadow directors. That must be right. And the distinction between executive directors and non-executive directors in that final paragraph indicates that what Mr. Justice Millett was saying is that it depends on what the individual person actually does. If you act in a considerable respect in relation to the subsidiary company, then you are at risk of becoming a shadow director or a de facto director. It's even more the case in de facto directorship, because de facto directorship depends on positive action. It depends on the person actually acting and doing things in the subsidiary, in the subject company. And we would submit that the case does not go anywhere near as far as the Court of Appeal interpreted it, and as the respondent seeks to suggest. The respondent's case brings in an element that in our submission one doesn't find from the judgment itself. Because in paragraph 21 of the case, in criticising the way we have characterised the decision, they say in the middle of paragraph 21, what that's Mr. Justice Millett, was distinguishing between was A, the director of a corporate director who steps outside his authority as such, and to use his phrase, individually and personally gives directions to the subject company without the authority of the board, and B, the director who makes active decisions on behalf of the corporate director, but within his authority as such. There is no reference in the decision to acting with or without the authority of the board. And this is not understood why the fact that acting within authority as such should be relevant to this question. I made the point that Eagle Trust itself has no lawful authority to act within the affairs of its subsidiary. Under what basis is it acting as such? And the source of its potential liability is shadow directorship, and whether it was actually giving directions and instructions to the subsidiary. But those directions and instructions are not being given by reference to any lawful authority that it has within the subsidiary board. Again, as I've emphasised, authority is only relevant as to whether Eagle Trust is potentially a shadow director, because the directions were being given on its behalf. The fact that they are being given on its behalf does not necessarily let the directors off the hook. So that is Heidelberg, that obviously formed the basis for the Court of Appeal's judgment. The other case that was also referred to in the Court of Appeal judgment is that of Secretary of State and Hall, which is in volume 6. At tab 51.
51.
51.
Thank you.
51 is the decision of Miss Justice Evans Loan. And as I explained at the beginning, this was a case where there were 3 de jure directors of the relevant company. One can see that from paragraph 1 of the judgment, there was a Mr. Hall, and in fact there was also, it appears from paragraph 5, a Mr. Allman were individual de jure directors of the subject company, Mercury Solutions UK Limited, but there was also a corporate director as the 3rd de jure director, Legal Directors Limited, and a Mr. Nuttall was the director of Legal Directors Limited. That appears from paragraph 2. And the situation was that Mr. Allman and Mr. Hall ran the company and clearly ran it into the ground. They were pursued for disqualification and were disqualified as the directors responsible for that having happened. However, the Secretary of State also pursued Mr. Nuttall on the basis that as the director of the corporate director, Legal Directors Limited, he too should be held liable for what happened. And Mr. Justice Evans Loam went through the authorities that we've looked at from paragraph 18 onwards, and at paragraph 29, just below letter C, says it's accepted Mr. Nuttall does not fit the description of a de facto director which emerges from Mr. Justice Millett's judgment in the Hydrodown case. This is because that description requires positive action by the individual, which demonstrates that he has been acting as if he was a director. The corporate director, Legal Directors Limited, did nothing at all. It didn't comply with its duties to the subject company. And apparently that was pursuant to some agreement with the executive directors that it wouldn't do anything. Quite why it was on the board as such is a bit of a mystery. But anyway, it did nothing positive, and therefore, of course, Mr. Nuttall, the person behind the corporate director, did nothing as well. And essentially, it was a case of non-feasance rather than misfeasance. And we would submit that even though Mr. Justice Evans Loam perhaps put it somewhat inelegantly, he was on to the right point, because he summarises it at paragraph 30. He says, I've come to the conclusion I cannot accept Mr. Cunningham's submissions. I've done so for the following reasons. So I've already pointed out the purposes of Section 6 of the CDDA, the Directors Disqualification Act, and Section 214 of the Insolvency Act must be similar, namely the protection of the public from errant directors. The term director is similarly defined in both acts. There can therefore be no justification giving that term a different construction for the purposes of Section 6 than that which it was given in the Hydrodown case for the purposes of Section 214. In the Hydrodown case, in the passage which I've set out above, Mr. Justice Millett finds the director of a corporate director is not, without more, constituted a director whether shadow or de facto of a subject company. However, I do not read his judgment as saying that this can never happen. I can well accept that an individual, through his control of a corporate director, can constitute himself a de facto director of a subject company. It seems to me whether or not he does so will depend on what that individual procures the corporate director to do. In theory, I am not bound by the judgment of Mr. Justice Millett in the Hydrodown case. Even putting on one side the authority of that judge in this and other fields of the law, I need convincing reasons for not following it. I can find none. So he clearly thought that he was following Hydrodown, and he clearly did not think that in Hydrodown, capacity was a relevant answer to this question. Because then in 3, he attempts to define when a director of a corporate director will become a de facto director. He says, it seems to me in order to be constituted a de facto director of a subject company, a director of a corporate de jure director must cause the corporate director to take actions with relation to the subject company as would have constituted it a de facto director of that company were it not already a director de jure. In other words, it has to be acting as a director. It has to be positively taking decisions, participating in the business, participating in all respects, along with the other executive directors in running the company. if it doesn't do anything, then nor is the director behind it, Mr. Nuttall, doing anything. He is therefore his actions cannot therefore be sufficient to constitute him as a de facto director. Obviously, the corporate director will be liable if for its defaults in failing to act, but the person behind it will not. In 4, he carries on, says, in addition, the degree of control which the director, the corporate director, exercises over that company will be of relevance. In the present case, Mr. Nuttall's control was absolute, but the situation may be substantially different where the corporate director is controlled by a board with a number of members with different responsibilities, which rather goes back to the point we were discussing right at the beginning. Equally, the shareholder control of the corporate director may be relevant. In the present case, Mr. Nuttall has not, either individually or through his control of LDL, taken any step which indicated either he or LDL had assumed the status and functions of a director of Mercury. They positively declined to do so. Follows that Mr. Nuttall, by contrast with LDL, was never subject to the duty to ensure Mercury kept proper books of account, complying with Section 221 of the Companies Act, or the 6 companies made proper returns to the company's registry. As a de jure director, LDL could be made subject to those duties. It seems to me there's no true lacuna in the protection which the CDDA was intended by Parliament to give to the public. If the Secretary of State takes the view that corporate directorships are being abused by a single corporate director acquiring a massive directorships of subject companies or by parent company of a number of corporate directors achieving the same result, it's open to the Secretary of State to present a petition against a corporate director or its parent to wind it up under Section 124A of the Insolvency Act on public interest grounds. Thereafter, if appropriate, to apply to disqualify any directors of those corporate directors. Now that suggested filling of the lacuna in public protection would not apply in our case, because there'd be no way that the Secretary of State would take action on public interest grounds against a single corporate director. There'd be no public interest reason. It would only be where one has a sort of serial abuser, a corporate director that's a director of a lot of different companies and is in some way failing to act. So it's really not it's not really a relevant point for our purposes.
So on the facts of this case, there was complete inaction on behalf of the corporate director, is that right? And Mr. Nuttall was not doing anything either.
Well, necessarily he wasn't doing anything, whether in the capacity as director of the corporate director or personally. Yes, that's right. He wasn't doing anything, and de facto directorship requires something to be done.
Yes.
You have to be actually acting.
I think we can see the nature of the case in the first sentence of paragraph 13, that the Secretary of State was trying to impose liability on Mr. Nuttall in a situation where LDL was inactive.
For the inaction of LDL, yes.
Although he controlled the company, it wasn't actually doing anything.
Exactly so. So Mr. Nuttall was not actually doing anything vis-à-vis Mercury, the subject company, because LDL wasn't doing anything vis-à-vis that.
Well, he wasn't doing anything vis-à-vis LDL either, was he?
Apparently not, although I think LDL was actually a director of a number of other companies which were similarly in default. So there, that's Mr. Justice Evans Loam's interpretation of hydrodone.
Yes.
And we would submit consistent with the underlying rationale of de facto directorship. Of course, the Court of Appeal disagreed and said that they couldn't understand that decision. And the Court of Appeal, perhaps we can...
Could you point to where that is, please?
Yes, of
It would be
course.
helpful to look at that.
In the Court of Appeal's judgment, if your lordships go to paragraph 68.
Yes.
Where Lord Justice Rymer says, whilst therefore I do not regard hydrodam as deciding the question of principle with which we're faced, I do regard it as giving a principled steer away from the conclusion that on the facts of the present case, Mr. Holland could properly be regarded as a de facto director of the composite companies. The judge did not apparently so regard hydrodam as more influenced by Mr. Justice Evans-Loan's decision in Nuttall. He then explains why he finds the reasoning difficult to understand. And then really the heart of the Court of Appeal's judgment is in the final few sentences of that paragraph.
Yes.
The relevant act in relation to the affairs of the subject company is an act directed by the corporate director, not one directed by the latter company's individual board directors. That may be regarded as a distinction of some technicality, but so long as we have a system of company law which recognises the difference between a company and its directors, it's a distinction that must be recognised and respected. Now, in our submission, of course there's a difference between a company and its directors. They are separate legal persons. There's no issue about that. That's why directors owe duties to their company. But it doesn't follow from that there's any special company law rule that requires, in this situation of principal and agent, that the capacity should be a complete answer to an allegation of de facto directorship. Because even though the relevant act we accept is an act of the corporate director, it is also a relevant act on the part of the individual concerned. And we submit that should be taken into account in considering whether that individual has become a de facto director. He then refers to the passage from Mr. Justice Evans-Loan's judgment, and then in 70 he says, that appears to me with respect to establish a somewhat artificial test. I do not understand its supposed basis. Appears to amount to no more than a proposition that a director of a corporate director will be a de facto director of the subject company if he procures the corporate director to direct the subject company in respects that would make him a de facto director were he to give it such directions directly. My judgment, the proposition is wrong in principle. I see no reason why a director of a corporate director is doing no more than discharging his duties as such should thereby become a de facto director of the subject company. But of course, as I pointed out, there's no reason for distinguishing between a corporate director and any other de jure director. If one had Mrs. Holland as the de jure director, and she delegated all her powers to her lawfully appointed agent, Mr. Holland, and he thereby controlled the companies in the same way as he did, why does that put it into a different situation? It's still a relationship of agent and principal. The fact that it's a company that is the de jure director is of no relevance whatsoever to this question. The only issue is whether the fact that there was an agent and principal relationship as between paycheck directors and Mr. Holland, whether that means that one can take into account capacity for the purpose of considering Mr. Holland's actions. And we say that if that Court of Appeal judgment stands, it will have huge implications, because any capacity will do. It's also possible that directors in the position of Mr. Holland would avoid criminal responsibility if they cause the company to commit criminal offences under the Companies Act. We see that from its Section 733 of the Companies Act, in Volume 8 of the Authorities bundle. It's tab 76. Towards the end of that
Yes.
tab, I think there's pages, but
Yes.
section 733.
No, it's quite easily found, yes.
I'm grateful. 733, offences by bodies corporate. Where body corporate is guilty of such an offence, and it's proved that the offence occurred with the consent or connivance of, or was attributable to any neglect on the part of any director, manager, secretary, or other similar officer of the body, or any person who was purporting to act in any such capacity, he as well as the body corporate is guilty of that offence. So this is obviously trying to put criminal liability and responsibility onto directors who cause their companies to act. But if Mr. Holland is correct, he obviously is not a director, a de facto director.
Might be a manager.
He might be a manager, although that is, I think, somebody who would be appointed as a manager, as such. And we need to look at the definition of manager.
I don't think there is one, is there?
We'll look at that, my lord. But he would also, it might otherwise be thought to be a person who was purporting to act in any such capacity. But if they're right, he will be able to say, I wasn't purporting to act in the capacity of a director of the composite companies. I was only purporting to act as a director of Paycheck Directors. And all my acts were in that capacity. So it would appear that if he is able to maintain that position, he could potentially avoid criminal liability as well.
Well, would that be a convenient point at which to break?
Yes, of course.
Well, we look forward to seeing you at 2 o'clock.